Tell me what I do to make this right for everybody else in this courtroom that has spent their time and money this morning.
Everybody else in this whole situation too.
Mr. Thorne, I
I don't have
understand that
any
you're
suggestions,
frustrated. And
All
you
right.
need to calm down.
Well, I do.
because
You're going
this isn't
to pay
great,
sanctions
okay?
in the amount of
Please stop
$5,000.
saying anything on the record.
I just don't
Get out of my
respect you.
courtroom now.
That's all.
That's fine.
Mr. Rhodes, tell me why we're
please-
here today. You asked for an
please
emergency
protect yourself.
hearing from my clerk yesterday verbally.
Ms. Arnold?
Yes, Your Honor.
We are
Well,
back
we're here
on
today, Your Honor,
record
because the court set the
in
emergency
City of
hearing.
Lakewood
Because you
versus
requested
Matthew
one, sir.
James Thorne, 23
Your Honor, what happened was-
You didn't appear at my hearing yesterday
Prior
again.
to the recess, there was some discussion about a stipulated
If I may
order of
respond, Your Honor.
continuance.
Please,
I now
I'm
have
waiting.
before me a
So,
motion
Your Honor,
to
as it relates to
continue,
yesterday,
the
non-apparent for
pretrial conference.
yesterday,
Is that correct?
the short answer is that it was
Yes,
not
Your
on my
Honor.
calendar.
So it was my understanding
the-
that
Were any of the
it's
other
going to be a
6
motion to
hearings you didn't
continue,
attend on your
but after,
calendar?
speaking
I don't
with the
believe it was
defendant,
6 hearings that I
I
missed.
think it is best.
Do you want to go through the
continue this
record
case
again?
until
No, Your Honor.
Monday, to allow
But Your
some
Honor,
time
what
for the defendant
happened
to
on
think about this offer.
yesterday, as relates to a hearing,
Okay,
as
that's
the
fair.
court is fully aware, there was a TI hearing in which was
Any
denied
objection
regarding
to
the
continue
sale of the
this
And you're
sound.
getting ready to go back to the
Monday
ancillary and try to
at-
overturn me again, right?
No, I'm not
Looks
going to
like
do that.
Monday
Your
at
I
Honor.
assure you, you're not.
So what happened,
We're
Your
maintaining
Honor,
the
there's
bell.
been communications between me,
I'm not gonna keep being
opposing
jailed for 5
counsel in
days just to
particular,
make me think, oh,
going back and
okay.
forth and trying to get the matter resolved as the case
Mr.
would be.
Thorne, I'm going to need
It wasn't
you-
until
I'm gonna
late
need you to try
yesterday,
and
Your Honor, not to
control
violate
yourself
attorney-client
so that I
privilege
can hear from the
communication. It wasn't until
attorneys,
late
okay?
yesterday
They're both liars.
that I was directed to seek, if it was possible,
Mr.
to
Vincent,
go
what
and
is the
see if we
city's
could have it
recommendation?
modified.
The city's
At that moment-
recommendation
Why would
that
I
the bell be
modify it
maintained
after
and
you've
this
had
be
6
set
weeks
over
to
Monday.
modify it?
Your Honor, I was instructed to
And
do
Ms.
it by my
Arnold, do you want me to
client.
hear
Where's your
on that?
client?
My
I
client,
instructed
No, Your
him to
Honor,
be here
that's
today.
an agreement.
Where is he?
All right.
okay, I have no
I'm
idea.
about to
Go
issue
ahead
bench
and
warrant. Where is he?
maintain
Your
pretrial
Honor, I
conditions
have
of
no
release
idea where
in
my
this
client is
matter.
at this
Okay.
moment.
We'll
But Your
set
Honor,
this
may I
case
may I
over
explain?
You may
to
not.
a new
I'm asking
pretrial
where your
conference
client is.
on
You don't know.
Monday at 1 p.m. Mr. Thorne, thank you.
Your Honor, if I
You
may
go ahead and
explain.
let the officer know that your hearing is
When I
done. We'll
called,
see you on
the
Monday.
court
Okay, I
The
don't
court
agree.
advised
I
that
don't
we
want
had
to be here on Monday.
an emergency hearing
If I'm gonna
scheduled for
be in
this
jail,
morning.
I might as
At
well
your
not play a
request.
little game against
I
pointing you guys.
advised my client of the emergency hearing on his
You're
status,
not gonna fuck me and make me.
the emergency hearing on his status conference.
That he was ordered to appear at.
Your Honor, I didn't, by the time I got the order, I was driving when I was speaking.
I understand you did it late in the day and I did it late in the day.
By the time I got the order and tried to reach out to him, I could not
Your
reach
Honor,
out to
can
him. I
defense
could not
request
contact
that
him.
Why don't you contact him right now and see where he
No, we
is?
don't need no recess. Fuck you, bitch. Get off the case. That's what we.
If I may, Your Honor?
Yeah, absolutely.
Yeah,
We'll do
go
it on the
ahead and mute
record.
The jail. Yes, Ms. Arnold, we can absolutely take a break.
I'd like an
recess.
address
Just
where
let me
he
know
is
when
because
you're
I'm
ready
about to
resume.
send out the constable.
Sure.
Yes, for best interest.
Of course. I trust you because I trust in everybody else in this whole situation too.
Mr. Thorne, I understand that you're frustrated and you need to calm down because this isn't great, okay? Please
don't
stop
respect
saying
you.
anything on the record.
I just don't respect you. That's all.
That's fine, but please,
Your Honor, this is
Please
probably the
protect
10th phone
yourself.
call that I've made.
Please record your
And this
message.
is what I did. I sent an email, I
We are
sent
back
text
on the
messages.
record.
When did you send the
in
last email to
City
him?
of Lakewood versus
Last email was sent to him
James
probably
Thorne,
at about 5 o'clock this morning.
23L000420.
Why didn't you show me that email?
Prior to the recess, there was some discussion about a stipulated order of continuance. I now have before me a motion to
Mr. Rhodes,
continue,
frankly, I don't believe a word you're telling this
the
court at this
pretrial
point.
conference. Is that correct?
yes, Your Honor. So it was my understanding that it was going to be a motion to continue, but after speaking with the defendant, I think it is best to
Deputy,
continue
find
this
out who's in
case
my
until
ready room, please.
Monday, to allow some time for the defendant to think about this offer.
Okay, that's fair.
I
Mr.
don't have nothing to
Vincent,
think about.
any objection to continuing this matter to Monday at, looks like
Yes,
Monday at
please.
1
I
p.m.
object. I object.
We're maintaining the bell.
You're
We're
not gonna keep me in
maintaining the
jail an
bell.
extra 5 days. just
Actually,
to
by way
make
of
me
correction,
think,
Your Honor, the
oh,
last
okay.
email sent out was at
Mr. Thorne, I'm gonna
7:24
need you-
a.m. this
I'm gonna
morning.
need you to try and
Okay.
control yourself so that I can hear from
And your
the
client
attorney,
doesn't want to
okay?
respond to this
They're
case?
both liars.
Mr. Vincent, what is the city's recommendation?
Does your
The
client want to
city's
prosecute this case
recommendation
anymore or
is
should I
they'll be
dismiss
maintained
it?
and this
No,
will be
yes,
set
he
over
does,
to
Your Honor.
Monday.
He does want to prosecute the
And
matter.
Ms.
Your Honor.
Arnold,
Where
do you
is
want to
he?
be heard on
I
that?
have no idea where he
Go find
No,
him
Your Honor,
right now.
that's an agreement.
All right. So we will go
I mean, excuse-
ahead
Yes.
and maintain pretrial conditions of release in this
Y'all
matter.
can step
and we'll
back.
set this case over to a new pretrial conference on Monday at 1 p.m. Mr. Thorne, thank you. You can go ahead and let the officer know that your hearing is done. We'll see you on Monday.
Are we on the record?
I don't want her to be here on Monday. I want a different lawyer.
Yes, sir.
If I'm gonna be in jail, I might as
Mr.
well
Rhodes,
not
any
play a
luck?
little game against, according to
No,
your
Your
guys'
Honor,
rules.
no luck in
You're not gonna
contacting
fuck
him.
me and you say thank you.
Mr. Simpson, Attorney Simpson was able to contact the daughter who advised
These bitches
that he
motherfuckers
was
off the street
in,
now. They want to go
Port
talk to someone
Arthur,
else and
and
lie to someone else.
also, provided me with another number. I tried contacting that number
Your
multiple
Honor, the
times,
defense requested
and
for
it just
you to
goes straight
recess.
to, actually,
No,
not even
recess, fuck you,
voicemail,
bitch,
says
get off
that
the
it's full.
case.
So.
That's
It's
what
clear to me your
now.
client doesn't want to
Yeah,
prosecute
go
this
ahead and
case.
mute the jail. Yes, Ms. Arnold, we
Why
can
didn't you
absolutely take a
appear
brief recess.
for
Just
6
let me know
weeks?
when you're ready to resume.
Sure.
And then you
Yes,
appeared
best
last week on
interest.
Friday. You didn't appear yesterday, and now again this morning, you're requesting emergency
Mr.
relief from
Thorne,
this court.
I understand that you're frustrated. and
Actually,
you
Your
need
Honor,
to
as
calm
I
down
mentioned
because
earlier, I did not appear
this isn't
yesterday
great,
because
okay?
the
Please
hearing
stop
was not on
irritating
my
me on the
calendar.
record.
I just don't
When,
respect
as
you.
directed by
That's
my
all.
client to see if there
That's
was
fine,
availability to have an
please-
emergency hearing, not
please
today,
protect
but later
yourself.
next week. the
Well,
court-
you're not getting anything later
Ms.
next
Arnold,
week. I promise
we
you
are
that.
back on the
Completely understand,
record
Your Honor.
in City of Lakewood.
I was
versus
advised that
Matthew
that they
James
were going to
Thorne,
have the hearing this morning, and I advised the court that we were not seeking a
Prior to the
hearing to seek
recess,
relief for today.
there was
Well,
some
but that
discussion
was
about a
after you
stipulated
requested
order of
relief from my
continuance.
clerk.
I
And
now
she
have
reached
before
out to
a
me
motion
late
to
yesterday afternoon.
Continue the pretrial conference. Is that correct?
Yes, Your Honor. So it was my understanding that it was
Tell
going
me
to
what
be a
I
motion
do to make this
continue,
right for
but
everybody
after,
else in this
speaking
courtroom
with
that
the
has spent their
defendant,
time and money
I
this
think it
morning.
is best to continue this case until Monday, to allow some time for the defendant to think about this offer.
Okay, that's
I don't have
fair.
any suggestions.
Mr. Vincent?
All right. Well, I do.
Any
You're going
objection
to
to
pay
continue
sanctions in
this
the amount of
matter to
$5,000.
Monday at,
Get out of my
it
courtroom
looks like
now.
it's Monday at 1
I
p.m.
object.
And those sanctions are payable by
maintaining the
you
bell.
directly, not your client. I will sanction him directly in the future.
Oh, okay. No.
Get out of my
Mr. Thorne, I'm
courtroom.
gonna need you to try and control
You're
yourself so that I
excused.
can hear from the attorneys, okay?
They're both liars.
Mr. Vincent, what is the city's recommendation?
The city's recommendation that bail be maintained and this could be set over to Monday.
Y'all on
And
the
Ms.
8:30
Arnold, do you wanna
docket,
be
have a
heard on
seat,
that?
relax.
No, Your Honor, that's an agreement.
All right. So we will go ahead and maintain pretrial conditions of release in this matter, and we will
I need
set
a
this
bench
case
warrant.
over
Want him arrested.
to a new pretrial conference on
need a bench
Monday
warrant.
at
Want him
1
arrested.
p.m. Mr. Thorne, thank you. You can go ahead and let the officer.
For
know that
anybody
your
on the
hearing is
8:30
done. We'll
docket
see
that
you
has
on
everybody
Monday.
here and is ready to
Okay, I
go?
don't agree. I don't want her to be here on Monday. I want a different lawyer. If I'm gonna be in jail.
What we just witnessed is a powerful example of how quickly a courtroom hearing can shift once credibility becomes an issue. At the beginning of this case, the situation actually looked somewhat favourable for the defendant. She had already negotiated a plea bargain with the state, which meant prosecutors were recommending 5 years of community supervision instead of prison time. Considering that the original charge, assault of a peace officer, is a second-degree felony carrying up to 20 years in prison, probation was already a significant opportunity. But in court, opportunities like that depend heavily on honesty and cooperation. And the turning point in this hearing came when the judge asked what seemed like a simple question: what will your drug test show today? This question wasn't random. Judges frequently ask about drug testing when someone is being considered for probation, especially in cases involving theft, erratic behavior, or a criminal history. The court wants to know whether the defendant is actively struggling with substance abuse because probation requires strict compliance with conditions like drug testing, counselling, and regular supervision. At first, the defendant suggested that the only reason a test might show anything was because of medication from the hospital after giving birth. But when the judge pressed further, the story began to change. Suddenly, she admitted the possibility of testing positive for methamphetamine, a very serious admission in a courtroom setting. From the judge's perspective, this raises multiple red flags. First, substance abuse can undermine a defendant's ability to comply with probation conditions. Second, the defendant repeatedly attempted to shift responsibility by suggesting someone may have mixed something into her drink. Courts hear explanations like this frequently, and judges tend to view them skeptically unless there is clear evidence. The judge then focused on something even more important, the welfare of the children involved. The defendant had just told the court she recently had a newborn and was responsible for several children. But if she was using drugs, or even spending time in environments where drugs were present, that raises serious concerns about stability and safety. This is why the judge mentioned Child Protective Services, not necessarily to punish her, but to make sure the children had appropriate support and oversight if needed. Another striking moment came when the judge questioned the theft itself. According to the discussion, the defendant had been stealing polo shirts from a department store, claiming they were meant for her son for Easter. The judge responded with a pointed question. Isn't Easter the celebration of Jesus Christ? Do you think Jesus would want you stealing? That moment highlights something important about courtroom dynamics. Judges often use moral reasoning to challenge defendants who attempt to justify criminal behavior with emotional explanations. While financial struggles and personal hardships can be real, the law still requires accountability. Ultimately, the judge accepted the plea agreement but imposed strict conditions. The defendant received 5 years of prison time suspended, meaning she avoids immediate incarceration, but must complete 6 years of probation under supervision. On top of that, she must complete drug court programs, parenting classes, community service, employment requirements, and regular check-ins with probation officers. Any violation could send her directly to prison. So in many ways, this sentence represents both a warning and an opportunity. The court has made it clear that the defendant's future depends entirely on her ability to follow these conditions and demonstrate real change. Now here's the question for you. Do you think the judge handled this situation fairly? Should the court have been stricter given the drug admission and the children involved, or was probation the right choice to give her a chance to turn things around? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.